Hello, everyone. We are Group 4B. My name is Brad Christensen, and we would like to share with you information regarding the European Code Law and the U.S. British Common Law. So to start off, we wanted to discuss what code law is. Now, code law is also known as civil law, and this is due to the fact that it was first introduced in Rome in the 6th century CE by Emperor Justinian, and it applied to the Roman citizens, or cives. I don't know if I'm pronouncing that correctly, but that is where the term civil comes from. Later in the Middle Ages, it was lost and then rediscovered in 11th century Italy, where it was adapted and it was used pretty heavily. It was taught in universities alongside church law, which is also known as canon. During some of the early modern time, in 1631, it was introduced to the Dutch system by Hugo Grotius, and again in 1786 in Austria, 1794 in Prussia, 1804 we had the Napoleonic Code in France, and 1811 Austria again readopted it and modified it. And as for the modern code law in Europe, it is in most European states with the exception of Great Britain, Ireland, and the Scandinavian countries. So what is code law? It is codified law drawn from legislation and custom, and also many of the settings put down from Roman law. It's comprehensive and continuously updated legal codes. So it brings up anything that has been brought before the courts or could potentially be brought before the courts, what the appropriate procedures are for it, and then applicable punishment for the offenses. So the way that it is drafted is that legal scholars and legislatures actually write the codes, and then judges decide cases based on the already written codes. Now, the intent of this is to systemize already scattered legal provisions and organize them with principles of civil and natural law. This is to try and standardize any issues that may come before a trial, that they may be considered fair and equal and require less interpretation. Essentially, defendants or prosecutors know exactly what's going to happen because these codes have been put in place to already predetermine what needs to happen. And next we will discuss common law.
Now let's talk a little bit about common law. Common law is also known as Cura Regis or the King's Court, British Common or US Common Law. Originally established in the Middle Ages, the King's Court was a single royal court focused on procedural remedies. It later evolved to become British Common Law and extended to all British colonies, continuing to evolve to become US Common Law, which was founded during the 17th century and resulted from British settlement of the North American colonies. Common law can be characterized as a body of unwritten laws based on legal precedents established by the courts. It influences the decision-making process in unusual cases if the outcome cannot be determined using existing statutes or written rules of law. It occurs by way of a presiding judge who determines which precedents apply to a particular case, and it also allows for adaptations in unanticipated legal instances. The intent of common law is the promotion of the common good. It's used to establish standards for acceptable conduct, prescribe punishment for violations as a deterrent, establish systems for enforcement, peacefully resolve disputes. It inspires stability and consistency in the legal justice system, and it can be used as an outline for what is considered minimally acceptable behavior. Here we can see countries that are practicing common law. They're shown here in several shades of pink, which correspond to variations in the common law systems. Additionally, you can also see here international use of code law shown in several shades of blue, which correspond to the variations in code law systems.
In code law, centralized officials write down the law and everyone follows those rules. It can be seen as more of a top-down method of setting law. Common law, on the other hand, can be viewed as something more like an interpretive art that is performed by judges. Judges set precedents based on the decisions they make regarding a case that they have heard. This is referred to as stare decisis, to stand on decisions. In the code law environment, judges are more heavily involved in the case hearing process and are sometimes referred to as investigators. They lead the proceedings, including pressing charges, establishing facts, and finally, determining results and potential penalties based on the legal code. Lawyers play less of a central role in the process than they do in common law arenas. Oral argument, in-court presentations, and active lawyering in court are less important in code law as compared to in common law countries. In addition, some tasks that common law countries require to be completed by someone with a full legal degree can be done by someone without that level of education. In common law, a fully trained lawyer presents the case to judges, and sometimes a jury, and they attempt to persuade based on facts. They also perform their own witness examination. Lawyers attempt to persuade based on these facts, and the judges play a referee. Code law is a bit more stagnant in nature, in that legal code can be added to or changed, but each individual case outcome based on legal code does not impact law. Judges make rulings based on the legal code that is established. On the other hand, common law is constantly in motion. As society changes, laws can change with it. There's no one written book of laws that can be followed from this day forward. Laws can be updated to be more fitting with the current environment in which we operate. However, this flexibility and adaptability does make the legal system much more complicated. Most people do not fully understand how the system operates.
Thank you. There are several implications that can affect a business or business executives as they're expanding or growing their business into other countries. And there's a few that I wanted to discuss today. The one is contract law. So in common law countries, it's a lot more common that they allow flexibility in the contract in every detail, and every detail needs to be spelled out. So you have these long contracts that explain what to do if this happens, and etc. Whereas in civil law countries, they're much shorter contracts and they have implied rules, and those can't be overwritten in a contract. So if there's an implied rule that every contract must follow, you can't go in and write something that is different than that, because it won't hold up in court. And executives need to understand this because of whatever country they're working in. They need to be able to write meaningful and accurate contracts. Someone that is used to writing civil law country contracts may find it a daunting task to write something in a common law, and they'll need more help and more expertise in doing so, and vice versa. The next area that we wanted to discuss is around business bankruptcy laws. It's typical in a common law country that they lean towards not liquidating the business, but restructuring it in an effort to keep the entity running, keep jobs and everything in place. Whereas civil law countries typically lean towards liquidating and closing the business out. So business executive would need to understand what the laws are in their country surrounding this, so that they know when they are considering a potential bankruptcy or restructuring, how they need to go about doing so. Security over assets. Common law countries will allow the assets to be held in a trust under lending situations, whereas in civil law countries, they will usually require that the assets be retitled by the new lender. This can affect the business executives in being able to borrow and lend in different countries as well. Bottom line is, business executives need to understand the laws and the legal systems, or have a team in place to help them in each individual country to meet the laws of that country. As Christina Ferguson says, establishing or expanding your business overseas may seem a demanding exercise under the best of circumstances, but when faced with a fundamentally different legal reality, it may become even more challenging. Thank you for attending.